Hey guys, I'm going to be going through Intoxication as Unit 3 defense. This is probably the hardest defense in my opinion, for me it's personally the hardest defense. I'm not going to go through the answers straight away. I'm going to go through the main outlines of the answer through my summary. Intoxication rarely succeeds as a defense, but if it does, it negates the mens rea. You must remember that. The main issues to consider are whether the crime was one of specific or basic intent and whether the intoxication was voluntary or involuntary. Specific basic intent crimes, a distinction was made in Majewski. A specific intent crime was one where the mens rea is intent only. So Section 18 Offence Against Persons Act. And a basic intent crime is one where the offence of the mens rea includes recklessness. So recklessness is basic intent, specific intent is intention. So it will be manslaughter or non-fatals excluding Section 18. Even in the specific intent crime, intoxication only succeeds if it negates the mens rea. So let me go through some cases because I haven't been through any. So for the first one, Lippmann, where he had taken drugs, he had no mens rea for murder, specific intent, but he was guilty of manslaughter. Majewski, intoxication was no defense. Mens rea for ABH includes recklessness, so it is seen as being reckless in getting intoxicated, so the mens rea is for the basic intent crime. In Gallagher, Dutch, courage is no defense. Voluntary intoxication, Lippmann was guilty of manslaughter, so this shows that for specific intent crimes, even if the mens rea of intent is not there, if there is still recklessness in voluntary taking unpredictable drugs, the result is a manslaughter conviction. Majewski was guilty of ABH. The defense could not be used because this is a basic intent crime. This shows that for basic intent crimes, the defendant will not be able to use the defense at all if the intoxication was voluntary. Remember, voluntary intoxication and basic intent crimes do not work because it is seen as recklessness as to getting drunk in the first place. DPP verbed. Voluntary drunkenness should be aggravating rather than a defense. Now, this is the easier part. Involuntary intoxication may succeed for both specific and basic intent crimes. Pearson, if a party may be drunk under stratagem or fraud of another, he is not to be held responsible. So you've got drugs, taking a medical prescription, Bailey. Sedative drugs, Hardy. Taken without knowledge, Allen, Kingston, in each. Now I'll quickly run through the answer. So I hope you guys understand intoxication before I go through this so it makes more sense. Intoxication may be raised as a defense. The main issues to consider are whether the crime was of specific or basic intent and whether the intoxication is voluntary or involuntary. The general rule is that voluntary intoxication is never a defense, DPP verbed. For basic intent crimes, the defendant will not be able to use the defense as if it was voluntary. So basic intent crimes, you can't use voluntary intoxication as defense. This was stated in DPP v. Majewski. The mens rea requirement for being is satisfied by the reckless behaviour of intoxicating oneself. In Lippmann, it was ruled that voluntary intoxication, however extreme, cannot be a defence to manslaughter. However, if the defendant was intoxicated involuntarily, it may succeed for both basic and specific intent crimes. Pearson, if a party may be drunk under stratagem or fraud of another, he is not responsible. And you got Dowd's, this rule that intoxication applies to all defences and to intoxication caused by drugs or other substances. So you've got the four main situations: taken under medical prescription, taken without knowledge, so that would be Hardy, quashed and stated the defence should be put to the jury. In Bailey, the prosecution proved that the necessary reckless element of the mens rea. Taken without knowledge, so Kingston, drugged intent is still an intent. Allen, intoxication remains voluntary even if the defendant did not know the strength of the drink. And each, the judge told the jury it was up to them whether the defendant's condition was solely due to voluntary intoxication. That goes through intoxication, and that pretty much covers all the models of Unit 3. I think the only thing that I have to go through is the critical analysis of the general defences. I've got an answer here, and it's a sound, but it's a bit long, so I don't know when I'll get time to do that. But yeah, I think I've covered pretty much the whole Unit 3 syllabus now. And yeah, hope this helped. These videos helped you guys, and take care, and good luck in the exam.